Hello and welcome to Arbitration Conversation. This week, we're going to talk to Professor Dave Larson. Now, David Larson is the premier expert on accessibility with respect to arbitration, mediation, and online dispute resolution. David Larson is also a professor at Hamline School of Law and a senior fellow of their Institute for Dispute Resolution. Moreover, he's incredibly active in the American Bar Association. He's helping to design online courts in New York, and he's just an all-around nice guy, and I'm proud to call him one of my friends. So Dave, thanks for being here.
Thanks for the invitation.
So what I wanted to talk to you about today is accessibility. Accessibility, especially when we think about how arbitration is currently being moved to a lot of virtual hearings. And what does that mean for arbitration? And what should arbitrators be thinking about in order to protect and promote accessibility in their virtual arbitrations?
Yeah, that's a big topic. Accessibility is really an important concern and for a lot of reasons, not only because of dispute resolution and arbitration and mediation, but the reality is that now our lives to a large degree are moving online in all kinds of different ways. To the degree that we're sheltering at home, that we're trying to socially distance, we're trying to stay away from crowds, we're working at home, our lives are just becoming enmeshed in a virtual environment. So some of the things I'll talk about don't just go to the arbitration proceeding or mediation proceeding, but I think go to website accessibility generally. But yes, we used to do our mediations and arbitrations for the large part in person, and now many people, in fact, almost all people that I know, are moving those things online. And once we start moving them online, we have to recognize that not everybody is comparably able, and they may need some accommodations to be able to fully participate.
What kinds of things would you make sure, if you're an arbitrator, right? Like, let's get real practical. As an arbitrator, what should I think about? What are questions I should ask?
Yeah, well, I like that last comment about what questions should I ask, because I think that's really important. A lot, when you talk about online mediation and arbitration, a whole lot of it, I think, goes to preparation. And you need to talk to the parties that are going to be involved, any witnesses that are going to be involved, and you need to talk with them and get some understanding as to two things, really, whether or not they need any kind of particular assistive devices or adaptive devices to access things online, and also just their general comfort with using any kinds of online platforms. Because if they haven't used whatever platform you're using, that hearing's probably not going to go very smoothly. So a lot of what I'm going to say isn't just relevant to persons with disabilities, it also may be relevant to parties who may not be familiar as you are with the platforms you're using.
So are there any platforms in particular that you think are better or worse for individuals from an accessibility standpoint?
Well, I think right now most people are just kind of moving to Zoom or WebEx or Teams or Skype for business or personal Skype. Most of those are just video conferencing platforms where they're going to give you audio and they're going to give you a video. And it's up to you to make certain that whatever you do in your proceeding is going to be accessible. So for example, it may be that one of your parties is hearing impaired and they're not going to be able to participate very effectively because they can't hear the audio over the platform. So you're going to have to think about some alternatives, whether or not you want to invite somebody to be a participant in the proceeding who can do sign language interpretation for you, whether or not it could be adequate if you can just provide a text-based simultaneous transcript to what's going on so somebody can follow a text-based. But the point is that you had a conversation with the parties beforehand, you had some understanding of what their needs may be, and then you begin to adapt to those. Now, if you're using just a platform like Zoom, I think you can do some of those things. I think you can provide simultaneous American Sign Language interpreter very easily on the screen. You might be able to provide live transcription of the oral exchanges. It's just a question of preparing before you begin. You might have somebody that's vision impaired. Well, they're not going to be able to see like others are, and you may be exchanging documents and sharing screens. So if you're going to do that, you need to make sure that you have either audio description or alternative text available, that anything that you're exchanging or demonstrating visibly is going to be accessible to somebody that's visually impaired. And again, it's just a question often of preparation. Um, so given that I think most people are not at this point using platforms, at least people I know, aren't using platforms that are trying to integrate any kind of artificial intelligence. They're just really trying to move what they do offline online, and they're doing it with platforms that provide video and audio. Then I think it's just a question of educating yourself and exchanging information between all the participants and preparing so that everybody can participate.
You know, one thing I've been kind of wondering, I'd love to get your thoughts on as well. Do you think moving to virtual hearings, do you think in some ways it actually helps with respect to accessibility, or do you think for the most part it can be a new kind of hurdle or something else that we need to address?
I think I think if done correctly, I think can think it'd be an improvement. Because often when you have to go to a physical location to even begin the hearing, that's a problem. If you got somebody with mobility issues, you've got somebody who's vision impaired, getting someplace unfamiliar may be a problem, and it may be a great improvement if I don't have to do that. So let's start from the idea that, well, this may be more convenient. But again, then you better make certain that you're going to be able to have full participation by everybody that's involved in the proceeding. And that's going to involve learning and listening to everybody as to what their needs may be.
And how about resources? If I'm watching this right now, I'm thinking, where can I learn more? Where can I learn more about maybe if there's possible standards or a checklist or other resources that are out there to help people as they navigate accessibility questions in their arbitration practice?
Yeah, and there's a couple of things to think about. One is that the actual hearing, and many people have their own websites where they actually kind of publicize their business, explain themselves. It's kind of an advertising function, also an information function. Sometimes they provide just information for the general public. So there's really kind of two things to think about. One is the proceeding itself going to be accessible when we're doing this relatively limited period of live person exchange of audio and video, but also that you may have things that are happening offline and they may be going through your website. And then there are a lot of things to think about. Let's look at let's think about your website for a second and not about the actual hearing. Well, if you have a website where you are identifying yourself and promoting yourself and maybe distributing helpful information, you need to know that that website is probably going to be under Title III of the Americans with Disabilities Act, which means it's going to be a public accommodation. And there's some discussion and controversy about whether or not a website alone that's not attached to an actual physical location where you're doing a business is something under Title III. You've got some splits and circuits, but I believe the much better rule and the eventual rule will be that the website itself is a public accommodation for purposes of Title III, which means that you're going to have ADA responsibilities. Now, having said that, the problem with the ADA is that it was a statute that was written in 1990, effective 1991, and it was really written for physical locations. And although there's lots of detailed information about how architectural design and workplace accessibility, it was not written for virtual environments. And starting around 2010, there were efforts to begin to write regulations as to website accessibility. Department of Justice was going to do that. They put out proposed rulemaking. That never went through. 2015, all that information was pulled back. The bottom line is that as we sit here in 2020, we don't have any kind of regulatory material from the Department of Justice saying this is what you need to do to be ADA compliant. All we have is language from a court that says, and a couple courts have confirmed this, says that, well, ADA does apply, but your only compliance responsibility is one that's flexible, quote, flexible, whatever that means. So that's the guidance that we have.
Not real helpful.
Not helpful at all. Now, having said that, there is helpful information out there. And one thing to look at are something called the Web Content Accessibility Guidelines, WCAG. And they've gone through a couple iterations and they have kind of several different levels of sophistication. And they're kind of technical, but that's a very comprehensive explanation as to how to make your conduct and behavior online accessible for persons with disabilities and all different kinds of disabilities. There is at Utah State University, they have a platform that's a Chrome and Firefox extension called WAVE, W-A-V-E. And as they explain, it's not really an acronym for anything. It doesn't, it's not a title, those 4 letters, but it's free. And it's an extension for your web browser. So for example, if you want to check to see whether the information you're putting online is accessible, you can for free run this disability checker called WAVE, and it will kind of highlight different things on your screen and make suggestions how you can make them more accessible. So one easy thing to do is to go get this WAVE, go to the platform and download WAVE and run it through your platform to see if anything is highlighted.
That's a great idea.
And you know, I think that speaking really kind of generally, some suggestions are, when you think about operating online, you should identify for yourself what you think are some good accessibility standards. Try and find what those are. The Web Content Accessibility Guidelines are one place to start. There's some other resources. I wrote an article that Ohio State published in their Journal of Dispute Resolution, and just did a book chapter in the same book that Amy also is going to be in. That gives a little more detail. That I just put up on SSRN, that identifies the treatise that this will be in the fall. But so identify some accessibility standards that you can follow. If you're a larger company or corporation, I think you should have an accessibility coordinator, somebody who's really paying attention to this, because things change all the time, they evolve. One problem with websites is that as they get more sophisticated and complicated and sleeker, sometimes they get less accessible because you know, they get more involved and complicated, and the accessibility unfortunately goes down. So if you have an accessibility coordinator, that person can pay some attention to that. If you're a large company, and even if you're an independent, to the degree that you're entering into any kind of technology support contracts with consultants or software providers, you should make certain that accessibility is part of those contracts, that they take responsibility to provide their software in a form that's going to be accessible, so that you don't have to do some kind of reformulating or adapting or rewriting or recoding. And that's something to be sure of. You're going to have to maintain whatever you're doing. It's going to, you have to pay some attention as things change. One important thing, and this is an easy thing, is whatever you're doing online, I think you need to test it. And when you test it, you should test it with people that have disabilities. That's probably one of your truest and easiest tests. To let somebody who's vision impaired or hearing impaired, maybe somebody's got a motor impairment, can't use a mouse very quickly or effectively, or a keyboard. Are they comfortable and are they effective when they try and use your website or your software? So certainly testing is important. In particular, using testers who actually are persons with disabilities.
What about though, if you are kind of, practically speaking, you're an arbitrator and you're just having to do virtual hearings for the first time now because of COVID-19, and you haven't had enough time to really look at all the different standards or to do proper testing. I guess you're just going back to preparation for the particular hearing and really focusing on those particular parties, or is there any way to kind of maybe do a dry run or some kind of a testing with the individuals before the hearing takes place?
Sure, there's no reason you can't go to the parties and say, we're not starting the hearing, but I'd like to, and it's a good idea anyway, this is the platform we're going to be using. I'd just like to run through with you to make sure you're comfortable using the platform. You know, if it's an arbitration, you got to be a little careful about having contact with one party and not the other party. You might want to do it simultaneously with the express understanding we're not going to be talking about anything an issue. This is just about getting everybody comfortable with the software. And even though I don't really see there's any ethical problem with doing that individually with each party, I think that might be the appearance of that.
Yeah.
The other party won't know.
Yeah, I wouldn't do it ex parte personally. I would maybe work it into a preliminary hearing of some sort, but that could actually be an important component of preliminary hearings now as we move into these virtual hearings.
Yeah, so even though temptation may be that to go, particularly if you know somebody has a disability and you think I'm going to have to spend more time with this person or at least get more information from them, the temptation may be to go to them individually, ex parte. But I would discourage it because it's just that appearance and suspicion of I don't really know what happened here, the other party might say. So I would try and do it with everybody again with the express understanding that we're not getting into any of the issues that are involved in this dispute. This is really just a question of getting comfortable with the platform we're going to be using.
Excellent advice. Well, gosh, thank you so much. As promised, I didn't want to take up too much of your time. So this has been Arbitration Conversation with Dave Larson. Thank you, Dave, for being our guest today. And thank you. I always enjoy talking to you.
Yeah, thanks, Amy. I appreciate it.